talk is about fair use, appropriation, adaptation, homage, or clear violations under copyright for visual arts. The first speaker will be Miss Fayen Mauricio. She is an artist and surface pattern designer. Brilliantly captures Philippine flora and fauna in her maximalist designs, raising products like kimonos, scarves, and wallpapers, with a rich history of collaborations including with brands like Adobe and fast retailing. She also ventures into the realm of game development. In this art talk, she will delve into her experiences and strategies in addressing copyright infringement and challenges. Another speaker that we have this afternoon is Attorney Marnie Thompson. He holds degrees in law and mass communication from University of the Philippines. His career spans roles at the Supreme Court's Public Information Office, the Philippine Senate's Legislative Journal Service, and GMA Network. In this talk, his expertise in various legal domains, including copyright law and visual arts, Attorney Marnie brings a wealth of knowledge this afternoon. Before we start, let's welcome Likhaan's founder, Ms. Isis Umali.
Hi everyone, thanks Kenny. Yes, today is going to be a really exciting day. We're very honored and super grateful to be working with Sansó Museum. We're super inspired to be in a very giving space. We'd like to really stress on the hearts of Director Ricky Francisco and Penny, of course, and everyone here, Sir Chris, Sir Don, thank you. Yes, Likhaan is just a little intro about Likhaan. This is a social e-commerce for Filipino creators, and we hope to really elevate the arts industry in the Philippines with the help of course, Sansó Museum. And so this is one of the first initiatives that we're doing, and we're hoping that this is not going to be the last. We'll continuously uplift the lives of the Filipino creators. So yes, grateful to be here, and I hope we have a really valuable conversation. Thank you, everyone.
So let's welcome Ms. Fayen as the first.
Hi everyone, my name is Fayen, and today I'm going to tell you what I did when my art got stolen. The year was 2012, and I was looking at this online t-shirt design contest that I wanted to join. And so, I was looking at their website, and then I wanted to look at their previous winners to see what kind of designs they won before. And then as I was looking, there was one design that caught my eye. And I was looking at this prize winner, and I was thinking, it looks so familiar. And on the right is my original drawing, and on the left is winning t-shirt design submitted by a person that I don't know. So as you can see, they took the tree from my drawing and then they used it in the t-shirt design. Of course, they changed the layout and the colors, but they used the exact same tree. They didn't get inspired by the style and then draw their own tree. So it's the exact same thing. So of course, I went into my online stalker mode, trying to find out more about who's this person who's using my drawing. And then when I looked at his portfolio, I saw that there were actually multiple t-shirt designs that this person had submitted to various t-shirt contest platforms. All in all, I think I counted a total of maybe 12 designs that this person had using my drawing. So you can see the side by side. This one's another one. To be fair, I think this person did a decent job using my drawings. I was like, I don't know, it looks nice in color and on a t-shirt, right? So, and some of them won these contests, so I was infuriated, but also kind of flattered, right? So this was the first time that my art got stolen, and to my surprise, I actually resolved this issue in less than a week. It was very fast. Within 1 week, I was able to get the designs taken down, the price was retracted, I got a formal apology from this person. I would say, I have to say thank you very much to our family friend lawyer who helped me a lot. This was attorney Ronald Ventura, not the famous artist, but a famous lawyer from Romulo Mabanta law firm. So, how come this was resolved so quickly? I'm going to talk about 3 reasons why I think this was so fast. The first is that it's a very blatant copy. When I say it's too similar to be a coincidence, what I mean is that they didn't just happen to have the same idea about drawing a tree and then they happened to draw it similarly to mine. It's just the exact same thing, so it's just very obvious. Secondly, it's a local case, so it so happens that this was somebody based in Makati. And so, I can just use a local law firm in order to pursue this case. And lastly, which I think is the most important reason, is that this person was cooperative. They said, sorry, it was not difficult to get them to agree to the things that I wanted. Basically, take down the designs, return the prize money, all of that. And all of the t-shirt design contest organizers were cooperative as well. They responded to me very quickly. And so, very luckily for me, especially for my first experience, I feel like I got it at an easy level, right? So, anyways, my takeaway from this experience is that I can sell my art as print designs. And so I was thinking, if someone is willing to steal my artwork to use as a print design, maybe someone out there will be willing to pay for it, to legitimately use it. And around 2 years after this incident, that was when I began licensing my art to various brands. And a few years after that, I was also eventually led into doing textile print designs myself and having my own brand with my own designs, like what I'm wearing today. And so I lived happily ever after doing my designs until the year 2018. And so in this time, I was lucky enough to already have a bit of an audience for my art. And I think I would get comments from people saying that they can recognize my art even when it's somewhere else without my signature. And so I received a message from a very kind stranger on the internet named Marie. So thank you, Marie. Marie told me that she likes this particular artwork of mine and that she spotted it in this shop being used for some clothing. And she was just asking me if I did this work for this brand, right? So again, going into online stalker mode, checking out this brand, I think you can see that the print looks quite familiar. I'm actually wearing my own artwork today. So I was like, wow, okay, that's definitely mine. It's definitely my print. Here you can see a side-by-side comparison, which I did. So this is my original artwork on the left. Then on the right is a close-up of the dress, one of the dresses they were selling. And I just encircled, like, there's the moon, right? Clouds. So just to help people see the things that match. And I think you can all agree it's too similar to be a coincidence, right? So an interesting thing that I saw on this brand's website is that they were claiming that all of their prints are hand painted by the founders themselves. And again, stalking their website, I found this Instagram post with the exact print saying hours of hand painting and sketching this print have paid off. So then I was like, oh, interesting. They're not just using it, but also they're claiming that they made it, right? So I sent this very polite email to this brand. At this point, I actually wasn't sure if they had stolen it because, like I told you before, I was already licensing my designs to various brands. And this particular print, I already licensed it to a lot of clients. And I wasn't sure if maybe they had maybe their graphic designer licensed the print on their behalf. And so maybe that's why I don't have their brand name in my list of clients for this print. So for this reason, I didn't right away accuse them of stealing my work. I just said, I don't have you in my records. I would just like to verify that you have the license for this print, right? And I also let them know that, I noticed that you're claiming to have drawn these prints on your own. So I'm just letting you know I saw it. This one took almost a year to resolve compared to the first one, which I think was kind of like the easy mode. This one is like kind of like a big boss mode all of a sudden. And let me tell you the reasons why I think this took so long. So just like the previous one, they are too similar to be a coincidence, right? The copy is very blatant, which essentially means I don't have much that I have to prove in terms of the evidence. However, it's an international case. So this brand is based in the UK, very far from the Philippines. And that means I cannot use a local law firm to go after them because you have to go after the perpetrator in the country or in the jurisdiction that they're in. So meaning I have to get a law firm in the UK. And lastly, so remember I told you previously the person who did that was very cooperative and they were sorry. So what happened was after I sent them my email, they kind of just ignored me. And then I asked a friend of mine, another lawyer, attorney Amanda Santos Mayer of Mayer and Mayer law firm here in the Philippines. I just asked them to send a formal letter on my behalf. Again, nothing accusing them of anything, but just asking them to please reply. And they finally replied, and the reply came from their lawyers. And it says, our client has not obtained a license, and our client is not required to obtain a license because our client made the prints on their own. There's a lot more, but this letter was also accusing me of attempting to piggyback on the brand's fame and other such things. And so what I can say about this is that, lawyers have to defend their client, so it's their job to be very vigorous in defending their client. So what I can say about this is that the lawyers are very hardworking, and this is one reason why it took so long to resolve. And to give you an idea of the amount of work that I put into resolving this case, together with lawyers who were helping me. So this is a database that I have where I was trying to find out more information about this brand. So I looked for various articles about them and interviews where they talk about, for example, how many pieces of a particular style do they produce. So my purpose is that I want to estimate like how much commercial benefit did they get from my design, right? So I have the links, the date that it was posted, the date that I took the screenshot, right? So everything very organized. And then here I have a list of all the instances where I saw them using my work on their various products. So of course, they have a product catalog on their website, but then it also appears in their various press features. So I made sure to catalog everything. These are my notes from studying copyright law because I wanted to make sure that I'm aware of how UK copyright law works. So one thing that I learned, for example, is that in the UK, the damages that you can get from a copyright infringement case are much less compared to the damages that you can get in the US, for example. So why is this? In the UK, they don't have a concept of punitive damages. So punitive damages are a kind of penalty that the offender has to pay because they're being punished, as compared to compensatory damages where it's a fee that the offender has to pay because they have to compensate the victim for the loss. So in the UK, if you have a copyright infringement case, you have to prove what was the commercial benefit that you lost in the infringement case. And that is the amount that can be awarded to you as compensatory damages, right? But if you're in the US, you can also say, aside from the commercial benefit, I had emotional suffering, and so you get punitive damages for that. So what I can recommend if someone steals your art, you better hope it's in the US. So, anyways, later on, almost a year after, we were able to resolve it. In May of 2019, my lawyers in the UK filed a case in the UK Intellectual Property Court. Then in July of the same year, we settled it out of court, and this is the public statement that the brand placed on their website, which we mutually agreed on. So I think thanks to the hard work of their lawyers and also my lawyers, so this was attorney Alice Edwards and attorney Rob Jacob from Stephenson Harwood in the UK. Thanks to them, we were able to resolve the matter in an amicable way, and we were able to move on from it. It took a lot of time, but we were able to do it in the end. So my takeaway is that it's really a lot of work, but it can be worth it. It's worth it because, so for one thing, I think that for any artist that this happens to, it really feels so unfair, and you really feel like this injustice has been done to you. And when you're able to get that justice for yourself, then it feels very satisfying and very validating, and that's what makes it worth it. Another thing is that it's hard to pull this kind of thing off, but if you're able to do it, then it actually gives you leverage in case it happens again. Which in my case, 2 years later, 2 years later in 2021, I got a message from a friend of mine saying that she saw this dress. Mabenta kasi yung print. What can I say? Mabenta yung print. Again, this is a brand abroad. So again, I was like, oh my god, it's another brand abroad. I have to get a law firm abroad again, it's kind of worried. So again, I sent my very polite email. Hi, I just wanted to check if you got a license for my work. But this time it says, by the way, this artwork was involved in a case and we were able to resolve our dispute amicably. Here, check out the story. So they can see I actually sued someone, right? This was resolved in less than a month, I'm happy to say, without getting lawyers involved. They replied and they were like, oh, we're so sorry, this slipped past us. We'll make sure it doesn't happen again. We'll talk to our graphic design team to make sure. We sold this much of the dress with your print. Can you just send us a bill? So that was easy. Again, like the first time. I think actually when it comes to this kind of thing, I'm pretty easy. You just have to be nice, say sorry, and pay me. Right? Easy. So these are my top 3 tips, just in case this happens to you. Check your claims, check your statements, and check yourself. Diba nga there's that saying, check yourself before you wreck yourself. Right? So the first one, check your claims. There's like billions of people in the world. So if you see something that looks like a copy of your art, you really have to think and be honest with yourself. Is it really a copy? Or maybe this random person had the same idea and they get inspiration from the same sources and they just made something in a similar style coincidentally. It's very possible. In a lot of cases, that's how it is. But I think one easy way that you can tell is if you can check the mistakes that you made in your own artwork. So for example, with me, you can see I'm not drawing perfect circles or perfect straight lines. And then you can see in the copy, like they have the same mistakes, irregularities, crooked lines. And so it stretches the imagination to think that they would have come up with the same idea and then they drew it and then they had like the same crooked lines, right? So that's one way to tell. Next, check your statements. So if you're going to publicly post about this issue, which is something I did, I posted about it on social media. Kasi maingay ako sa mga issue na ganito. But I checked with my lawyer first, and I yung statement ko, it was like how many paragraphs long, and basically my lawyer chopped away like half of it. So, to give you an idea. I'm gonna give you this line for free, which I learned from my lawyers in the UK. This is the kind of line that you have to say if you're going to make a public statement, right? I find it hard to believe that the similarities are merely coincidental, right? So, you're not accusing anyone doing a crime. You're just saying it's hard to believe. They even made the same mistakes. Find it hard to believe that it's merely coincidental. So this kind of line, it's giving mataray, but I cannot be sued for libel. Right? So, lastly, check yourself. Like I said, it can take a lot of time, bandwidth, effort, luck, privilege to pursue a legal case, and it's really, honestly, totally okay if you have better things to do with your time. So you're the person who was wrong, right? And if this happens to you, and so it's your right to choose how you're going to deal with it. And for some artists, they just don't have the time, they don't want to deal with it, they just want to focus on making more art. And I think that's a totally valid way of dealing with an issue like this. The really important thing is that they chose that not because they didn't know about their other options. So it's just important to be aware of these other options that you have, and then you can decide which option you want. And that's it. That is my presentation. Thank you so much.
Quick question. So, Fayan, you said you licensed your designs. That protected you from the infringement as well, right? So, can you guide us through the licensing process, like very shortly lang? And what are our options if you cannot license it?
Sure. Thank you for asking. That's a very important question. I think that licensing my designs, it was kind of a double-edged sword. So there were pros and cons. So let's start with the disadvantages. When I was licensing my artwork early on, so this was around like 2014 was when I started, I was licensing them through a stock art website. So a website that you just go to and you can just click and buy the artwork. The disadvantage is that if you're licensing through a platform and not directly, then you don't have a lot of information about your client and how they use it. It's just going to show up in your sales records as the date, and then the username, and then how much they paid for it. And that's why I always have to start with a non-accusatory email just to ask them if they legitimately licensed it or not. Because syempre, I don't want to give a legitimate client a hard time, right? But the thing is, I don't have enough information. So that's the disadvantage. However, the advantage is that because I put it up on a platform, so this is a website where they include the date when you originally posted it, it's very easy for me to prove that I have a record of owning and publishing this artwork at a certain date. So in terms of copyright claims, you have to be able to prove that you published or created the artwork at a certain date earlier than the other party. I also just got lucky because this other party was claiming that they created the artwork in 2016, but I have the licensing art platform clearly dated in 2014. So that was lucky for me. Okay, thank you.
Can you give us, especially artists, an idea of how much it would cost to litigate, like to sue your the offender, the one who stole your art?
Okay. So the fee will really vary depending on the law firm. I would say for an international case, you have to prepare maybe to start with maybe at least $1,000 to begin. But anyway, this is why I'm saying it's better if it gets stolen in the US because the damages are higher in the US. So actually, in the US, I think lawyers are more willing to work on a parang commission basis where they only get paid based on the winnings of your case.
Following to that, you're saying that there are different copyright laws per geographic country. Yeah, so it's case-to-case basis depending on where the offense was made.
Yes. So unfortunately, like that's the difficulty of pursuing an international case. It depends on the laws of the country and also the culture of the country regarding how strong their copyright protections are. So for example, personally, I am unlikely to pursue a case in China. However, I was talking about this with Ricky yesterday. But there's actually a successful case in China where an artist was successfully sued for plagiarism by, I forget if it was an American or European artist. So it's difficult, but it's not impossible.
Thank you so much.
Thank you.
For our next speaker is Attorney Marnie Tonson. He's one of our go-to attorneys with regards to art law and copyright and other intellectual property rights. So Attorney Sansó will guide us through the basics of copyright today. Thank you, Attorney Marnie.
Good afternoon. The title of my presentation is Appropriation versus Plagiarism and Fair Use versus Infringement. These are four terms, four concepts that I intend to tell you about, and so that you'll be able to differentiate appropriation from plagiarism and fair use from infringement. Okay, so first we're going to talk about appropriation, then plagiarism, then we have to inverse it: infringement, copyright infringement, and fair use. Okay, the very first thing that a law professor would tell freshman law students is that what is ethical, moral, may not necessarily be legal. And what's legal may not necessarily be moral. Because there's a very distinct line between the two. When it's violated, ethics violations are unethical, not illegal. Who enforces it? Society, government. It covers what? Ethics covers morality, while law covers legality. This is very important because you cannot claim such things as moral crimes, okay, because they're not outlawed by any law. And again, what is ethics mostly about? It's mostly about the character of the individual, as opposed to law, the liability or what you can hold that person accountable for. There are things that are in the realm of ethics, there are things in the realm of law. Okay, so ethics, well, at least ethics in art, would protect the artist's community, while in law, it protects the copyright. Okay, it's copyright is a form of intellectual property. We will go on to that. So here we have the four terms or concepts that I'm going to try to explain. Plagiarism is a violation of ethics, while infringement is a violation of law. This is important because you just can't say, okay, you plagiarize my work, I will sue you. Because you cannot sue someone for plagiarism. But you can sue that person for copyright infringement, which is a totally different thing. Then, what is the defense against plagiarism? Affirmative defense is a legal term. It means that you accept the violation, but you say, I have an excuse for it, or I am exempted from it. So, if you are, if there's a claim of plagiarism against you, you may take the defense of appropriation. Okay? One good example would be saying, it's just an homage. Okay? But the thing is, you have to prove that it is actually an homage and not plagiarized. It's the same thing with law. The fair use is one affirmative defense against infringement. Okay, so 2 days ago, I found this in my newsfeed. An Indian actor won a case against artificial intelligence. When I saw the word appropriation, automatically my lawyer's thinking came into play because there's such a thing called appropriation of likeness. which I later found out is totally different from appropriation in appropriation art. So I went down that rabbit hole, and for the past 2 days, I've been researching on appropriation art. Okay, so going back to appropriation of likeness, this is the law that Mr. Kapoor probably relied on. Okay, it's a tort law. A tort is a civil wrong. It's not really a crime, but it's wrong nonetheless, and that's why you can sue for damages. So here, it protects the various aspects of an individual's identity from commercial exploitation. Name, likeness, achievements, identifying characteristics, and years apart. Actual performances and fictitious characters created by a performer. Okay, so if you're following what's happening in Hollywood lately, they've been striking, and one of the demands is that studios won't use AI of their work through performances. Okay, so here we have an example of AI used in appropriation, but this is an homage. Okay, why is it an homage? This knockoff of Girl with a Pearl Earring is part of a contest based on the actual Vermeer painting. Okay, so they didn't hide. They're not saying that this is a Vermeer. They're not saying that it's original. They're saying that it's an homage. So this is not plagiarism. This is not copyright infringement. My most recent experience with appropriation art, which I did not know back then was appropriation art, was by this Filipino artist, Busher. As you can see, these are images that look familiar. Because you know this one right here is Papa Smurf. You have Jake from Adventure Time. You have Snoopy from Peanuts. And down here you have Odie from Garfield. Okay? It's easy to recognize them. Now, this is what makes this type of appropriation art acceptable, well, more palatable. And most probably, these Kombusher cannot be sued by the studios or the syndication that markets these cartoon characters. Okay, so I had to go look for the artist's definition, because in law, definitions are very important. Because how a thing is defined, how a right or a property is defined by law controls. So I looked for the art term appropriation, and this is what I learned. It's a practice. Artist, it uses pre-existing objects or images. This is the most integral part. It does not claim to be a one-off. It does not claim to be something original. It has little or no transformation of the original art that was appropriated. Okay, so then I checked the dictionary definitions of the root word of appropriation. Okay, at first I was thinking, just like in law, it pertained to the verb to appropriate or to make one's own possession. Okay, but then if you look at the definition of the adjective appropriate, it's more apropos to how it's used in appropriation art. Because the creation that you're presenting to the world has an appropriateness. And how that appropriateness or how suitable it is or fitting to the current milieu would give context. And that's one thing that I learned with appropriation art. It's all about recontextualization. Because, like, as shown by the works of Kombusher, unless you're familiar with Saturday cartoons or Western cartoons, you would not be able to appreciate that those pictures were actually pictures of Papa Smurf, or Jake If you're familiar with the Rudyard Kipling poem, The Conundrum of the Workshop, I'll just read it out. When the flush of a newborn sun fell first on Eden's green and gold, our father Adam sat under the tree and scratched with a stick in the mold. And the first rude sketch that the world had seen was joy to his mighty heart. Till the devil whispered behind the leaves, "It's pretty, but is it hard?" This poem articulates what appropriation art is, because it puts the question to the audience if it's art. When you research on appropriation art, you see that the artist presents something that's obviously not his. Okay? So this guy, Marcel Duchamp, presented this urinal. He didn't make it, he just bought it. He just put it on a pedestal and just wrote there R. Mutt. I have no idea why R. Mutt is. Well, he just wrote there R. Mutt, then 1917. Okay? This was rejected first, then he complained about it, then it was accepted into an exhibit. So he called these things ready-mades. Okay? So if you go to a copyright lawyer, he'd be scratching his head because I don't know how this was able to make it to an exhibit. But then it was explained that the art did not bring anything new to the world except a recontextualization. It was given new meaning. Okay? So later on, Sherry Levine in 1991 created an homage to, I believe the title of this work is The Fountain. So she made a golden fountain this time. This is another work by Duchamp. The title is LHOOQ, which if you pronounce it in French, well, it would come out as L-H-O-O, cool. Okay? And the meaning is, I was told, she has a nice, she has a hot booty. Okay? So it shows how incredibly irreverent this movement of appropriation art is, because it intends to shake up the audience, to give new meaning to something like the Mona Lisa. Okay? So Duchamp did not say that he is the original. He did not say that this is an original. Because there's no way that you can understand the work unless you understand that this is the Mona Lisa. And as you can see, even up to 2004, you have transformations made on the original. Now, that word, transformation, is important in law because you find it in the actual copyright law. Okay, here's another one. Andy Warhol took some photographs and made silk screens. He's famous or notorious, depending on how you look at it. He did not take the photographs. I mean, he did not click the shutter. Okay, he took photographs from other people, taken by other people. Okay, so you have here Marilyn, and it was appropriated and transformed by a Chinese artist, Hu Yuhan. Okay. And it was part of his, if you're not familiar, part of his Mao series. So you have Marilyn's Mao, Marilyn. Now we go to plagiarism. Pablo Picasso, a cubist, well, not only cubist, he's an all-around artist. He's famous for saying, "Good artists copy, great artists steal." Okay. So people have wondered about what he meant by that. Actually, we're not even sure that he said that. Because some people say he said, "Good artists borrow, great artists steal." So, what is it? Did the good artist copy or borrow? Then you have this. The bad artists imitate. The great artists steal. Okay? And as you can see, this was scratched out, the name of Pablo Picasso was scratched out. It was by Banksy. And of course, us in this 21st century, we're familiar with Banksy. Okay. So, what is it now? Good artist, bad artist? Is it copying? Is it borrowing? Is it imitating? But as you can see, the common thread there is that it all says that the great artist steals. Is it true? Is there this appropriation that is illegal? Is it a crime? In 2021, if you're not familiar, the guy who invented cut, copy, paste passed away. This guy has done so much to the world of copyright law, and he's not even aware of it, most probably. Well, he wasn't aware of it. Now, this is what happened to our first speaker. And when I Googled her, the first article that came up was this article from Rappler. So, the question here is it plagiarism or copyright infringement? When I read the story, I was looking for any statement about plagiarism. There was none. It was about copyright infringement. So, was it plagiarism or copyright infringement? Okay. I'll tell you right now, it's both. It can be plagiarism and it can be copyright infringement. But you can only sue for copyright infringement, not for plagiarism. Okay, so what is plagiarism? It's intellectual theft. Theft, real theft, is a crime. It's a felony under the Revised Penal Code. But intellectual theft, it's not really a crime. Okay? Why? Because it's stealing ideas. Think about that. Ideas. Okay? Now, the etymology of plagiarism comes from the Latin plagario. Okay? A plagario is a thief who steals children or slaves. Kidnapper. Okay? So, again, remember, plagiarism and copyright infringement are not identical. Why is that? Because of this thing called the idea-expression dichotomy. Okay? This is always taught in copyright law classes. Okay? You can only protect expression, but you cannot protect the idea. Because if the idea is just there in your head, then you see it come up somewhere, you say, oh, that's my idea. It doesn't make sense. Okay? You have to express the idea, and only the expression can be protected by law. Why is that? So far, there are no mind readers in the legal sphere. So there's no way they would know that it's your idea. You have to express it. Even then, the idea is not yours, it's the expression that's yours. Here are some questions of whether it's plagiarism or not. When you copy the day's lesson is written on the whiteboard. Okay, so this is part of my class in copyright law. Okay. Sketching on paper the Rizal Monument. Is that plagiarism? Taking several photos of a painting. Is that plagiarism? Okay. Again, it has to be intellectual theft. So all of the examples are not plagiarism. Here's one example of plagiarism without infringement. Self-plagiarism. Few people know that they can self-plagiarize. What does that mean? Okay. You join one contest, you have a painting. Okay. It won second place. Then another contest, and you join it again. Not telling that the contest organizers that you submitted the same painting to that and it wins for first place. That's self-plagiarism. Okay. Is it legal? Not in the infringement sense. It's the same artwork. Okay? But it's illegal because it's basically estafa. Okay? But it's a different crime. It's not infringement. An example of infringement without plagiarism. Okay? in law school, we have lots of these things. It's called bookalikes. If you're not familiar with what a bookalike is a Xerox book. Okay. Law books are really expensive. So you would find several law students coming to class with bookalikes, Xerox of books that are actually published, and since they're expensive, they're Xerox. And of course, the teachers were really angry, telling them, "You're committing a crime in my class." Okay, so that's something that you never do when you're in law school. You can't bring a bookalike to class because it's a crime. Okay, now what's copyright infringement? To understand copyright infringement, you must first understand what copyright is. Copyright is intellectual property. Property calls to mind ownership. It's a relationship between owner and property. Is art property? Yes. It's intellectual property. Are ideas property? Again, idea expression dichotomy. You cannot own ideas. You can only own expression. So right here we have the three major types of intellectual property. Copyright is just one of them. Now, these three primary kinds of intellectual property have their own bureaus. Under the Intellectual Property Code, RA 8293, we have three bureaus: the Bureau of Copyright, the Bureau of Trademark, and the Bureau of Patent. So for our purposes, we're only interested in the Bureau of Copyright, Intellectual Property Office. Okay, take note that works of art include not only literature, but also computer programs. This is a fascinating subject, but we'll not delve into that. But this is the part that's important: originality. Again, when we're talking about appropriation art, are we talking about originals? Because what happens is you appropriate a certain artwork into your own artwork. So how can you call it original? We'll go into that. Copyright is property, and property is a bundle of rights. Why is it called a bundle of rights? Okay, you have rights of possession. You have the rights to reproduction. You have many rights, and it's a bundle. And you can give away, assign those rights to other people, like in licensing. Licensing is a form of giving away parts of those rights in that bundle of rights, property that you own. So intellectual creation is how intellectual property is made. Take note, copyright registration is not necessary. Okay? The right to a work of art begins when you start expressing it. So you don't have to go somewhere, you don't have to go to the Bureau of Copyright to have that right over your work. Your right to that work starts from the moment of creation. So it's very important to understand that, because the important thing in copyright is originality. And root word, origin, it comes from you. That's why it's easy to say that, oh, this originated from me because, again, we discussed this and it was exhibited in 2014. So if you come up with something in 2016, then obviously you're not the originator. So that's how originality is determined, from the moment of creation. Okay. Copyright is separate and distinct from the material object. Okay, so let's say what happens is you own an art studio. Okay. Somebody broke in and used your art material to create a work of art. Okay. And you catch the guy who broke in and used your materials. To whom does the artwork belong? Okay. this is a standard question for law students. The answer there is that the artwork belongs to the one who broke in. But since he used your materials, you have an action against him for the use of those materials, but not to the artwork. You cannot say, oh, since you used my paint, you used my canvas, that belongs to me. You can't say that. But you can charge that person for the paint, for the canvas, and for the crime of breaking in. Okay, it's a totally different thing again. Okay, so that's the paint on canvas example. Then you have derivative works. Derivative works are based on previous works. In the case of our first speaker, Ms. Mauricio, her drawings were made into clothes. Okay? The clothes are the derivative work. The originals are the drawings. So you can own the derivative, or you can have a license. Again, bundle of rights, you have given that license to a certain fashion house. Okay, so derivative works are translations or adaptations of the original work. Okay, so let's say comic books, Spider-Man. Okay, who owns Spider-Man? Now that's sort of a trick question, because which Spider-Man are you talking about? The comic book or the movies? Okay, because Marvel Comics would own Spider-Man comics, while the studios would own the movies that are produced. So for a time, it was first with 20th Century Fox. Sony. Okay, it was with Sony. Then they had him licensed back into the Marvel comics, a Marvel Cinematic Universe. So that's how it works. That's how copyright works. Because these bundle of rights, they sold that particular character, so they have to license him back into the cinematic universe of Marvel. I always tell my students that copyright is mostly about fame and fortune. Okay, so what you have here are the moral rights, the fame, and the one that's most important to this discussion is the right of attribution, or to attribution. Sorry for the paternalistic or the sexist term paternity right, but it's what's been used in law. Okay, the right of attribution is saying that, okay, that's my work. So if the work is not attributed to you, there is a violation. That's already an infringement. Economic rights, this is the fortune part. Okay, it's getting paid, the royalties. Okay, also getting paid for subsequent sale. We always tell our clients the importance of this thing called it's a French term, droit de suite, or rights that follow. What happens is when you create a painting or a visual expression, you sold it to somebody else, then that person sells it to somebody else. Okay? You have a 5% of the sale price commission for each subsequent sale. Okay? Some artists don't know about that. They think that, okay, once I sell it, that's it. I won't earn from it anymore. It's not right. Because each subsequent sale, 5% of the sale price belongs to the painter. Okay, that only applies to painting and sculptures. Okay, this is my pet peeve. I keep on saying CEO. it's wrong. Okay, you do not give credit to the owner if you do not name the owner. Okay, this is a this is common in social media, and it always gets my goat. There's a substantial similarity. That's Ms. Mauricio already explained to us what substantial similarity is. Okay. There's also a difference between copyright infringement and art forgery. Art forgery is a separate crime. Okay. In art forgery, this is where authenticity is important. Okay. Not only originality, but is it authentic? And there are certificates of authenticity that's given out. But we won't delve into that. And again, differentiate copyright infringement from plagiarism. These are the defenses when you are charged with copyright infringement. Okay? First, you say there is no copyright protection. Why? The works are not protected. Okay? What does it mean that it's not protected? Usually it's in the public domain. Or the period of copyright protection is lapsed. What's the period for copyright protection? It's 50 years after the death of the creator. Okay? Then there's an optional, I think, 20 or 50 years also, that the heirs could earn from that. But I think it's still limited to 50 years. I haven't checked if there's been any change in the law. Okay. Then one of the topics in this talk, fair use and parody. Okay. These are the defenses that you give when you are sued for copyright infringement. Okay. These are the 4 factors for fair use application. These are the factors that the court will look into in order to decide whether it's not copyright infringement because it is fair use of that particular factor. First is the purpose and character of the secondary use. Okay. Was it done in order to make money? Is that person or that other creator of that derivative work saying that, okay, I copied it, let's say you copied Spider-Man, okay, and you start selling Spider-Man costumes. Take note, it's different from cosplay. In cosplay, you make it for yourself and you show your love for the character by dressing up. It's different when you make that particular costume, you start selling it. Okay? In that case, you're committing violation. You're committing infringement because you're making money out of somebody else's work. But if you're expressing your love for the character or cosplaying, then that's not infringement. You can use, well, that's one of the 4 factors. Oh yeah, for that. What I'm doing right now, I'm using pictures and text from other sources. Okay, I did not get permission for those, the use of those things. Okay, I can claim under this non-profit educational purposes. Okay, so it's safe. So if you're instructing, okay, you're not saying, oh, that's my work, or no, I paid for that presentation. No, it's an exception. So the amount of sustainability, substantiability, amount and substantiality of portion. Okay, what does that mean? It doesn't mean that just because you took a small part of it, that's not infringement. Okay, because it could also mean that what you took, the smallest part, happens to be the very heart of the matter. One example of that is, I forgot the name of the case. There was a book that was licensed, and somebody came out, a news magazine came out with a full story, and it had only around 300 words about that particular topic. And so the news magazine said, okay, that's an entire book. We just took 300 words out of a thick book, and that's not substantial enough. The ruling of the court there was that it's substantial because that's the heart of the matter. Those 300 words are what everybody's interested in, and you put it in an unlicensed news article in your news magazine. So that's why the claim of fair use was not accepted, because it took the heart of the original work. Then again, the effect of the use upon the potential market, not just actual market, but the potential market, that would somehow devalue the original work. Okay. Now, these four factors are not; they don't have any set rules. Okay, because it's always on a case-to-case basis. So be forewarned that when you use somebody else's work without their permission and without any right to use it, like licensing, you can only go so far with the defense of fair use. Fair use is a valid defense, but you have to prove that you are within that exception, and that's very hard to do. Now, this was decided only in May. I explained in the previous talk on artificial intelligence why this particular case is important. Okay. What happened here was that a photographer had photos of prints taken. I think her name is Goldsmith, and her photos were used by Andy Warhol in making I think 16 prints, silk screen, using her photo. These 16 prints called to mind this earlier usage by Andy Warhol. He's famous for taking silk screens. I believe this is the Campbell Soup Cans series from 1961 to 1962. He made 32 silk screens of Campbell soup. Why 32? Because they had 32 types of Campbell soups. So he wasn't sued for this by Campbell. This was allowed. Then again, the earlier Marilyn print. He made several copies of the Marilyn print also. And that picture was taken, that photograph, which was made into a silk screen, was taken by somebody else. Okay, and he wasn't sued for that. So how come in this earlier case, and this later case, with prints, Andy Warhol lost? Okay. In a 7-2 decision by the U.S. Supreme Court, it stated that Miss Goldsmith is entitled to a part of what the Andy Warhol Foundation earned from this series, this print series. And the right of the photographer as the original artwork owner was enforced. Artificial intelligence, what they do is they train the generators, the AI, with previous works. Okay, so you have previously existing work. So it's a bit like attribution art, but it's not. Because what you have is a machine that scrapes artwork without the knowledge of the artist or the creators, that they're being used in order to train a machine come up with images that look sort of like what you made, but are not yours. So the question there is, like in the case of Andy Warhol versus Goldsmith, do the original artists have a right to what's created by AI? This is going to be decided on by the US Supreme Court, hopefully sometime this year. Here pertains to stock photos. Stock photos by getting images, okay? Their stock photos were used without the permission or the licensing from Getty Images of these photographs. Okay? Again, without the permission of the stock owners. Okay? So here it says 1.8 trillion dollars lawsuit. So we'll see if the Prince case, the Warhol Foundation versus Goldsmith case, would have any bearing on these cases. I can't say for certain, but I'm pretty sure that this will weigh heavily on these two cases when the Supreme Court of the U.S. finally rules on it. Okay, so that's it. Okay, thanks.
Hello, I'm also super interested in the Warhol case. I'm just curious, if Prince were still alive, would he also have some kind of claim over the image, due to what you mentioned earlier about the likeness?
Yes. Actually, what will happen is that Prince's claim to his likeness is under, again, the torts of appropriation of likeness. So if his image was used for commercial purposes, then I would say that he has some claim to that. So like, if it's made for artwork, okay, it's his image. He has a right to claim compensation for that. I'm just not sure how much, but again, it would be the court that would decide.
I don't know if you mentioned this, but with the difference between the Prince and the difference between the Prince case.
And the Campbell case was just enforcement, like Campbell could have.
Yes. The thing there is that I would say that the argument for appropriation art in the Campbell soup series would be a lot stronger, because what happens there is that it was a commentary, social commentary of commodification. So I would say that the artist, I'm not sure you could call it the illustrator, whoever made the wrap around the cans, I don't think they would have much of a case for that, because it is social commentary and it's protected under fair use. So in the case of Prince, the court has already ruled that the photograph that was used was for a different purpose. Because in that particular case, in the Prince case, the photograph was taken in 1981. Then the Warhol Foundation made Prince in 1984, based on the photograph by Miss Goldsmith. And Miss Goldsmith wasn't informed. Then she later found out, because one of those prints, one of the prints of Prince, okay, actually became a magazine cover. And that's how she found out. Okay, wait a minute, that's my photo. It's just colored. Okay, I didn't give that magazine that picture. The Andy Warhol Foundation gave permission to that magazine and got paid for by that magazine. So in that case, it's a clear-cut violation of the rights of the copyright owner of the original photograph. So it's clearly infringement. But in the case of again capital suit, it's a commentary.
I have several questions from our online viewers. One is, what is the boundary between fair use and accountability for commercial use?
Okay. So I would say it will fall under the first and fourth factors because that's where commercial use of the art is made. Again, the crime of infringement, copyright infringement, prevents or protects the creator from somebody piggybacking on his or her work. Because what happens there is that, again, if your art is being used by somebody else without your permission, then your rights as an owner gets violated. So there's no real hard line, but it weighs heavily the commercial use of the original art in the secondary use. So it's up to the courts to decide if it does fall under the fair use exception and say, okay, you did infringe, but you're not liable because there's fair use. You have to present your case fully and well in order to avail of that exception. Because again, there was infringement, but it can be called infringement because it was fair use and it didn't really harm the creator.
Another question is copyright transferable automatically to the next of kin upon death?
Okay. So, copyright is considered intellectual property. So, property would transmit to the heirs upon death, yes. So, it's important to understand that the nature of property, because intellectual property is created, is made by creation, by expression. Then the right to inherit is not really created. Succeeds from the death of the decedent. So you have two ways of transmission of property. One is from creation, and the other is from the death of the decedent. So, as long as it's property, yes, it will transmit. It's just a question of who the heirs are.
Next question is, at what point or percentage of editing should be okay not to be flagged? Example, if I use an image and edit it as a part of another work, how much edit should I do? Is that even quantifiable? For example, siguro collage art.
Okay.
Because there's a lot of collage artists, and some collage artworks, they use images from certain photographs, from magazines, or characters from other books, and then make an entire artwork image using those.
Again, that's the part on appropriation art. Collaging is a valid way of transforming the original. Now, transformations are derivative work, and normally it's the original artist that has rights to transformations. But in in appropriation art, what happens is it's normally done without the knowledge or permission of the original artist, and it can only be allowed if 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 it falls under fair use. So it would be for the courts to decide. So unfortunately, yeah, you would have to go to court to
So,
try.
follow-up question. This is my own question naman from that answer is, so yung mga fan arts of specific characters or animes that are being sold by a lot of artists all over the world, is that illegal? If that falls under appropriation, right? Or what?
Well, actually, that's a trick question because the answer there would be depends if the studio or the original creator would sue. There was a time when I handled some of the cases of the Mars Radar group over Darna, and that was always a question for them. What about the fan art? What about the cosplays? Would that be infringement? And my answer would always be, don't run after the smoke there. Why? Because that's free marketing. So it's up to you if you want to go against fan art. But if you go against fan art, that's the opposite of marketing. You're hurting your brand image. Okay, so it's a version of the unethical versus illegal. Okay? Here naman, it's about marketing. If you want to protect your intellectual creations, then you should learn how to loosen the leash on holding it back. Because fan art, in most cases, helps the original artwork. In Japan, this is very prevalent because they do fan art all the time. And unlike in the States, wherein if you dress up as one of the Disney princesses, they would go hard on you, and that's not how it's done in Japan. If you dress up as Luffy, then well and good. You're promoting One Piece, and it actually strengthens the brand. So if they would come to me for legal advice, don't go after the small guys.
This was asked through internet earlier today. There was this case of an art piece here in Manila that won an art competition. The image of this art piece is half of it is taken, there was this photographer in Taiwan who took a photo of a son taking care of an ailing mother, and this was painted by a local artist here, and then he juxtaposed his mother taking care of him when he was young underneath that, and it won a contest. Was there a copyright infringement here? The photographer in Taiwan did not give permission to the Filipino painter to use the image.
I would have to qualify the answer there. Whether if it's a private photo, it's not widely distributed, then most probably it would be infringement. But let's say it's a news story, and it was shown in newspapers, then I would say that it would be enough to call for the exception of fair use. But if that photo was for a limited run only, or it was in a certain book, and the artist appropriated that from that book, then it would be harder for the artist to claim fair use. So I would say, yeah, it would depend on how the original art or the original photograph was used.
I wanted to add to the question about fan art. I also have like a follow-up answer. So Attorney Marty already gave the advice like to the IP owner, which is don't go after your fans, basically, which I very much agree with. Because that's your fan community, right? So my advice naman is, so for example, the late great Anne Rice really hated fan fiction of her vampires, and she would legally pursue these fan fiction authors, which to me is kind of crazy, but that's her legal right. So yun lang. So parang do your own research. Check if the IP owner is actively pursuing. But I definitely agree, you know, it's not cool to go after your fans.
So earlier we talked about how art and sculptures usually you sell them, and each time it's resold, the original creator has a right to claim a percentage of that. But my question is, and this goes back to our first speaker, who someone used her artwork for clothes. What if someone buys your art and then uses it for something like that? Since it's resold now in a mass production, but they used it differently, it's not the original artwork anymore. But since technically they own it, they're just using it for some other material. Is there also a claim for artists who will say, oh, that's still my artwork, it's just being used in clothes now, but it was still mine originally?
Yes, that will fall under derivative art. So, if derivative art is made from the artwork that was bought by someone else, the artist still has claim to that. Because again, it's the expression that's owned. And even if you own the expression, and you're the new owner of that expression, actually you're not the owner of the expression. You're the owner of the thing. So if it's a painting or a drawing, you may hold the canvas itself, you may hold a piece of paper, you own that, but the expression still belongs to the creator. The bundle of rights paradigm works. Because when you sell something and you're the owner, you can sell parts of the bundle, strands of the bundle, and not the entire bundle itself.
Yeah, usually
Yes.
it's just the artwork itself,
So,
not the rights.
yes. And a primary example of that is the paternity right, or the right of attribution, which is, falls under the moral rights of the creator. What happens there is that just because you bought a painting, you can't like say, okay, this is my painting, it's now made by me. Okay? It can never be done. Because under the current laws on intellectual property, the right of attribution is inalienable. It follows the creator all the time. And oh yes, I just remembered Ms. Mauricio was talking about different intellectual property laws. In the laws of a nation usually follow its territory. So laws in the UK are different from laws in the US, are different from the laws in the Philippines. But in order to make things work, they entered into treaties. And the most important treaty for intellectual property is TRIPS, the Trade-Related Intellectual Property Rights regime, which is a treaty that almost all countries have signed to. So what happens now is that you have standard clauses, standard provisions in intellectual property. And some of these, well, most of these are subscribed by certain countries. So I think in the States, it's still 70 years after the death of the creator, but the world standard is 50 years after the death of the creator. So there are slight differences. So it would be easier to find out which provisions of the TRIPS, the Regulated Intellectual Property Rights regime, is being followed by which country. And before I forget, the whole thing about damages, Okay, uh, she's absolutely right about the application of punitive damages. Uh, Punitive damages is apparently not that much enforced in the UK, but it's done in the States. And thankfully, in our jurisdiction, punitive damages is also a part of it. And more so, there's also this thing called moral damages, and that's the sleepless nights and stress that you get, as long as you can prove it. Like, I had to go to a psychiatrist. Here are my bills. Okay, you can claim moral damages. So it all depends on which provisions of the trips is subscribed to by which country. So in case that you have to sue abroad.
If your profile, like art profile, is sa Instagram or Facebook is public, and when you post your artwork online, does it fall under fair use? Kasi some AI generators uses images from Instagram and Facebook. So does it mean that what AI generators does is illegal? I don't know if that makes sense. But
Actually, just because it's on social media doesn't mean that you relinquish your rights to that particular artwork. Now, if the question is artworks that's posted on Instagram can be seen, then can it be appropriated? The short answer there is no. There was one artist, I can't remember his name. What he did was he got photos from Instagram, then made an exhibit based on the photos. Then the, that's why I can't remember his name. His last name was Prince. Okay, that part I remember because yeah, why is Prince always a subject in intellectual property? So this guy, the artist whose last name is Prince, okay, he had an exhibit. He pulled from Instagram photos, then he just changed the text under it. So what happened there was that his claim was that it's appropriation, art. Richard Prince. So what happened with Mr. Prince was that he got some photos from this this group called the Suicide Girls. Okay, and the Suicide Girls are this bunch of women who like to dress up in sort of punk rock get up. So their group was angry at Mr. Prince. Then they found out that Mr. Prince was selling those prints of their Instagram posts for $5,000 a pop. So when they found that out, they immediately made their own prints of their own Instagram accounts and sold those prints for $500. And as a lawyer, I would say that that was one of the most class A reactions to infringement, because instead of spending money to go against Mr. Prince, the Suicide Girls flipped it over and hurt his reputation as an artist by saying, "Oh, those prints are not $5,000 worth; just $500 over at Suicide Girls." Okay, so in that way, you can see that Instagram posts, you don't give away anything, and if you can sue, I would say you should.
Attorney Marnie already mentioned, it's still kind of ongoing, right? They're still deciding it like in the courts in the US. But if you want to look more into it, then I highly recommend a paper written by an information law scholar named Ben Sobel. He's based in the US. It's SOBEL, so bensobel.org. His paper is titled Artificial Intelligence, the Fair Use Crisis. So it's talking about how AI training has always conventionally relied on the fair use defense. So for example, Google Books successfully used the fair use defense because they're saying, we're not competing with the original books. We're just providing information about these books to people who want to know more about the books. It's not a substitute for buying the book. You're wanting to find out more info about the book, right? And he calls it non-expressive use case of the original work. However, in his paper, he argued that with AI training, the AI generators are actually producing work that is expressive because the work produced by AI generators is not metadata about the original work. You're not learning anything about the original work, actually, and it does displace the original works within the same market. So remember in the fair use principles that Attorney Marty discussed, the concept of how it might harm the market of the original work. So he was saying it doesn't necessarily disprove the defense of transformative use, but it does disprove the particular defense of it being a non-expressive use. So it's a very, very informative paper. It was written several years ago, but it's still very relevant today.
Thank you.